We're going to get started since everyone seems to have their lunch. For those of you that I haven't met, I'm Amanda Brulette, and I'm the other editor-in-chief of STLR. Welcome. Thank you all for being here. It's my pleasure to introduce our keynote speaker, Michael Carroll, who is a professor at American University Washington College of Law. And he is also one of the founding members of Creative Commons, which helps to promote the sharing of creative works. And I'll just let him get right to it. Thank you.
All right, thanks very much. Audio okay? I'm going to roam. We good? Okay. I have a number of slides. I'm going to do the, I know I will fail, but I'm going to try to compete with what's so interesting on all the screens in front of you. So the slides will come fast and furious, and hopefully that'll keep you with me. So when asked to do a keynote about digital copyright, I had to think about what to focus on. And I assume when we talk about digital copyright that we're mostly interested in copyright in the digitally networked environment, because there's a sort of earlier story about computer programs and how copyright law came to deal with software, and I've chosen not to focus particularly on that, and instead to focus more on copyright meets the internet. And one of the things that has happened to me is I've been teaching internet law for more than 10 years now, and the issues and the cases that were fresh and just happened yesterday are now fading into history, and I'm now realizing that things that I think everyone is familiar with, my students are saying, oh, I didn't know about that. That was back in the 90s. And so I actually am going to look back to look forward today. I think it's important to put some of the recent digital controversies around copyright into a broader perspective. And as I look at the sort of demographic of the room, there are many of us in the room who sort of lived through this. And so do treat it like it just happened yesterday, and for others I imagine it will be fairly new. I also thought, well, the students invited me, what do the students want to hear about? The students probably want to hear about where's the action. When I went to law school in 1993, I was an older student, but I knew the internet was the place to be, and it was just a question of being a copyright lawyer or a communications lawyer. But I knew the internet was where the action is. Good news, the internet is still where the action is. But we'll talk a little bit about that. And just to drop in, for those of you who have to write papers or notes, I've got at least 3 paper topics to suggest during the course of this, this talk. All right, so this presentation is brought to you by the letter L. No, not that, this, right? That's a trademarked phrase. Okay, why the letter L? If we think about copyright in the digital environment, I want to think about the decisions that have been made that help shape this environment by lawyers. And those decisions are legislative, they've been made in litigation, and they've been made in the course of licensing. We train students in law school to focus on what happens in litigation. It's where the lawyer's domain. But I want to argue to you that I think actually decisions that have been made in the legislative and licensing context have actually had a more profound effect on how the internet works. And I want to suggest that we still have a number of issues that have yet to be litigated. They will be litigated. But the action is moving away from litigation toward licensing, at least in terms of making decisions that are going to shape the internet. As a lawyer, if you're good at legal analysis, the litigation is often more fun and more interesting, so I get that. But in terms of if your goal were to shape the next decade of the internet, the decisions made in licensing conversations, in my view, will be have more profound effect in that regard. All right, so let's talk about legislation, and let's go back 20 years. For those who can't remember how to do the math, I'm talking about 1993. So U.S. Department of Commerce looking at this web that has now been made public and says, gee, this is sort of this gee whiz moment. Look at what this internet thing could do. You could have a device that could do all of those things, right? I don't know. What are they talking about? Are they crazy, or do they mean that? So when I talk about legislation, I also want to talk about policy making more generally. One of the important things to think about is the different fora in which the public policies that have shaped copyright on the internet have been made. And only some of those decisions have been made in the US Congress, and even when they're made in the US Congress, they're often made in dialogue with decision makers in other fora. So it's important if we step back, sort of if I had a preface, the preface would talk about the move toward globalization, the World Trade Organization Agreement, and the TRIPS Appendix, which sought to make a uniform baseline of intellectual property rights run across the world. And that TRIPS agreement comes into effect in 1995, but it had been negotiated prior to that, prior to the internet becoming part of people's daily lives. And so internet issues were largely not dealt with in the TRIPS agreement. So you have this long legislative process that gets resolved just at the moment when its relevance is diminished somewhat by this new technological development. And the copyright requirements in the agreement are based on the Berne Convention, which goes all the way back to the 19th century. It's very technologically specific in some of its provisions. Most of those rely on analog technologies. TRIPS at least recognizes the software issue that had been around for a while, resolves it in a way that locks us into the view that software is a literary work and therefore must be treated as novels and other kinds of work, gives countries less flexibility to create sui generis regimes to deal with software because they are now required to treat it as a literary work. If you look at where the action was in Congress, Congress was still focused on a lot of industry-specific deals. Now that has been the characteristic of a lot of copyright legislation in the US, but the 1976 Act was a grand bargain to refashion, reframe, and package these deals into one big agreement. Subsequent to that, we got these sort of targeted interventions. So we get, satellite technology comes along, the cable industry had been dealt with, satellites needed to be dealt with. We have the threat of the celestial jukebox, that record companies that had been making money off of radio airplay in the analog context fear that with streaming digital audio, you won't buy music anymore, you'll stream it. So to some extent, they actually were pretty forward-looking. They saw that risk in 1995. It's really only being realized in a serious way now. But they did identify the risk and said the way to protect against it is to make sure that we get paid either way. And so that's what that act is. We also start to see the enforcement, digital enforcement coming up. We get judicial decisions that Congress doesn't like, and they respond to that. In addition, so we get the Audio Home Recording Act, which was going to solve the great digital problem of digital audio tape. Digital audio tape. So sometimes Congress doesn't see ahead too far. In the meantime, outside of and Congress had been the traditional policymaking forum for copyright legislation. Bruce Lehman, who had worked on the Hill during the 1976 copyright revision, is now the Assistant Secretary of Commerce. He's the head of the Patent and Trademark Office, but his passion is copyright, and he wants to deal with copyright on the internet. So he pushes the administration to do a public process, a public consultation, and as part of a task force, issues in 1995 a white paper that's going to set the rules of the road for copyright on the internet. So its vision is, you've got to secure the beach. We've got all this valuable content. It's going to go into this digital space, but you've got to secure the beach. So we've got to get laws in place, technologies in place, that make it safe for this content to come onto the internet and know that the owners of the rights in that content will enjoy the full economic value of those rights. And so the national priority is to secure the beach. Now, in the course of doing that, the white paper makes a number of assertions about how copyright law applies to the internet that many academics and others viewed as being a very aggressive move. Rather than treating as settled quite open and contested issues about retransmission and distribution of copyrighted works. And as Professor Samuelson wrote an article in Wired that got wide circulation that suggested that the Clinton White House was eager to please Hollywood in the lead up to the 1996 election, and that the white paper was part of that initiative. In the meantime, in the air is a different view about what the internet is. Game over, says John Perry Barlow. Forget this copyright stuff. That was yesterday. You weary giants of the industrial age. We are in a digital age. Copyright is over. So that idea, at least, is in the ether as one of the things to be contested. The white paper actually responds to the declaration, or at least the arguments in it, that cyberspace should be treated as an independent jurisdiction and domain. But the white paper does not get a particularly energetic reception on Capitol Hill. But Bruce Lehman, as the executive branch's ambassador to the international organizations, does something that, even if you disagree with the substance of the policies he pursued, and I will confess that I do, you have to give him credit for being creative about circumventing inertia in Congress. So he goes to the World Intellectual Property Organization and sort of revives that forum as a place to make policy, and two international multilateral agreements are entered into in the recognition that the TRIPS agreement had not dealt with this. So we get the WIPO copyright treaties that, among other things, require digital rights management technologies to be protected from circumvention, defining the distribution right to include the mere making available on the internet, having a communication right so that it was clear that the public performance right through distance technology would apply as well. Again, reiterating that software is a literary work for those countries that hadn't joined the TRIPS agreement, and also articulating how digital databases would be treated, and that the fact-expression dichotomy would exist. The facts are not protected by copyright, but the expression in the organization and arrangement of databases would be. Now, this is not a copyright act, but it also in the air is the Communications Decency Act, which has in it a provision that deals with internet service providers. So you kind of have these parallel universes in which the copyright industries and the copyright-related interests are pushing ahead in sort of traditional fora, while internet service providers are responding in particular to defamation liability, but seize an opportunity when members of Congress realize that there's porn on the internet. I tell you, there's porn on the internet. And so they rapidly pass this law, and the communications lawyers deftly insert into that law this immunity from liability for a series of claims. And after the Supreme Court strips away the anti-porn part of the legislation, the immunity remains. But that immunity does not apply to criminal law or to intellectual property law. So internet service providers have a great deal in terms of the liability. So if you take Andrew Bridges' perspective about managing liability risk, great deal with respect to some sources of liability, not a great deal with respect to intellectual property liability. So now let's go back. So now we're 15 years. Anyone want to do the math? That would be 1998. Okay. Now, apart from those specific targeted industry interventions, we start to get framework decisions. There's been enough talk, there's been enough consultation to start making some big decisions. Now, again, these are controversial. So we get the Sonny Bono Copyright Term Extension Act, which indirectly leads to the creation of Creative Commons after Larry Lessig represents Eric Eldred, loses the case that challenges this law on constitutional grounds and says, what do we do next? So we get 20 years more of copyright. This is a framework decision. It applies across the board to all works of copyright. We also get the Digital Millennium Copyright Act. Now, this is a package deal. It's not as big as the 1976 revision, but it rolls together essentially 4 different deals that had been in the works. 2 of them are important for the internet writ large. We get the WIPO Copyright Performance and Phonograms Treaties Implementation Act, which gives us what many people think of when they say DMCA, which is sections 12 or chapter 12, which requires that there be liability for people who circumvent or traffic in technologies that circumvent technological protection measures. But that's only one part of the deal. In order to get that part of the deal through, a separate piece of legislation that the internet service providers had been shopping around gets rolled in, and that it has this oscilla, this odd title. It becomes Section 512 of the Copyright Act. And in addition, then you get these odd little ducks. You get vessel hull design protection and computer maintenance to react to a particular case. Now, what's interesting is I was practicing law at this point, and I spoke to a lawyer. We represented a large media companies. And he was not directly involved in the day-to-day negotiations, but he had worked on the Hill, and he was familiar with the lawyers who were. And when looking at this deal, it was clear from the content industry's perspective that the digital rights management was the key piece of this legislation, and that the safe harbors for ISPs was considered almost a sort of, they were legislatively weak. If they had really wanted to get this up against a strong adversary, they probably wouldn't have gotten it. The content industries were more interested in getting the DRM into law quickly, and the ISPs had at least enough leverage to slow things down. So they did not treat this as a particularly big deal, and particularly, if we look at Section 512C, which is the safe harbor for storage at the direction of a user. So any copyright infringement that may arise by reason of storage at the direction of the user. And the reason that content industries did not consider this to be a particularly big deal is that they thought this was mostly digital landlords. This is web hosts who are worried about people who are building websites, and maybe there's infringing stuff on that. And from their perspective, landlord liability had already been sort of dealt with in real space, and these digital landlords looked as if they were analogous enough that, sure, that seems like a reasonable point. And we've seen in the recent cases that this history is being litigated again in both the YouTube versus Viacom versus YouTube and the UMG Records versus Shelter Capital Partners. The copyright owners have basically said, we want to undo this. Sorry, wait a minute, this wasn't the deal we meant to do. We didn't realize that this was going to become the platform for user-generated content. We thought this was about digital landlords. And the Ninth Circuit in the Shelter Capital case rejects that assertion, as they should have, because on the scene at the time when this deal was done was a little website called GeoCities, which later got bought by Yahoo. Now, people didn't think about it as what it became, but it was functionally a version of YouTube. It was a place where you could build a website and post it, and they would host it. But they were more than just a hosting site. They wanted to do a deal with you. They wanted to, once Yahoo took it over, they wanted to be able to throw ads up against your content, and they'd share the revenue. A lot of the models that get made more robust with the so-called 2.0 or UGC sites were present in 1996. Here's a picture from the Wayback Machine of what GeoCities looked like. So this was in the record at the time. It just wasn't appreciated for what it represented. If you want the full story, so there's one L word is Bruce Lehman, another L word, Jessica Littman, who tells you the story about the sort of legislative run-up to the DMCA in detail in her book. Now, from my perspective, I think when we look back, Section 512C ends up being the far more economically significant decision that was made as part of that legislation, because DRM just doesn't work the way the content industries thought it would. The analog hole is not a problem that's readily solved. Now, for those of there's a certain triumphalism among techies that we told you so. We knew that. right? But let's be careful, because a trusted platform is different. At the file level, distributed DRM is easy to break. But in a cloud-based internet where we all are relying on a small number of platforms, the analog hole still exists, but the ability for the DRM to be more effective means that I'm giving you my judgment about what's more significant based on what we know right now. In 10 years, I could easily be reversed by the course of history, or maybe not easily, but it's possible. And we certainly see DRM on ebooks as being more effective, more widely deployed than it was for other kinds of content. Whether that's sustainable or whether the demands for interoperability overcome that, I think the pressure for interoperability is pretty great. But at least at this moment, the DRM is out there and it is hacked when it needs to be, but we don't see, we still see people paying for DRM content. Nonetheless, 512C, what makes it such an important decision, it's about platform. It creates the ability to build on a platform, right? You can manage the risk, invest in the platform, and as a result, we get a series of these platforms. And my contention here is that these companies would have been created with or without Section 512C. But the investors who've put, at this point, billions of dollars into these companies may well not have without the safe harbor protection. What about this one? Right? This is the newest darling in the story, but I think it's a nice case study in the flexibility that 512C creates, the space to innovate. So originally, this was a mobile app. This story may already be well known. I'm probably in the wrong place to tell it, but this is, again, somebody who's a little too far ahead of the curve. Mobile is where it's going to be. You're right. It's just not the place to be in 2008. So by observing what people are doing, pivot, the web is a more stable platform. Let's build this UGC site on the web where people can share photos. Not quite sure why they want to. Ben Silberman admits, I'm just following the data here. Users seem to want to see stuff on the internet. They store a picture for themselves. I'm not sure why they're doing this, but just as Twitter wasn't sure what it was about, and the users kind of told them, let's let our users tell us what we're about. So 512 renders the copyright risk manageable enough to get some patient capital and some early capital to find out what it is that the users are up for. So he's explicit about this. Okay, yeah, you're taking a lot of copyrighted photos off the internet. What are we going to do about that? So he's a data-driven former bug collector, so you pin your bugs, right? His girlfriend names the company, but it's users, most of whom are women, who have told him, no, this is what we're doing. We need to communicate visually with each other. We have to make all these decisions about how things look, how we look, how our house looks, how dinner looks, and we communicate visually, and that's what we're doing. And he's like, okay, that's fine. I can build you a website that does that. And you can see that that's what's going on by looking at the most popular categories where the pinning is happening. And now at this point, the company's able to go out and be seeking $2.5 billion in capital. And I just find it hard to believe that they could do this, given the amount of copyrighted content that's on that site without authorization, notwithstanding the terms of use that we saw earlier this morning, if you didn't have 512C in place 10 years ago. We don't have to do the math now. We're in the new millennium, right, 2003. So we get a run of enforcement legislation. This is where Congress wasn't focused on what a great job it had done with 512C. It was still about securing the beach. We've got to get this internet thing secure. There's no respect for copyright. And so we get a series of enforcement measures that increase the statutory damages, that make it a crime to go into a movie theater and film a movie with a digital camera, to shift some of the enforcement resources from the private sector to the public sector. And that's where Congress's energy is. You know what? I'm sorry, I duplicated that. In addition, this is important for the folks for whom SOPA and PIPA was this dramatic moment of where the heck did this come from? Well, where the heck this came from starts at least in the early 2000s with some legislation that didn't make it into law. But we have this sort of copyright owner rage against the machine, that the DRM's not doing what they thought it was going to do. And so their content is not secure, the beach is not secure. So what we need to do is plug that analog hole, and the way we do that is by getting to the machines themselves. We've got to set the rules for what the device makers can and can't do, and Fritz Hollings had a bill that would have required device makers to include kill switches for unauthorized content or permission switches for authorized content in order to operate as the solution to the problem. That then becomes a modified, after that gets rejected, it becomes a more modified version, which again does not get followed through in Congress, but the FCC adopts a version of that theory in the broadcast flag as we get a transition to digital television. FCC orders digital television manufacturers to put this little switch into the device that says, if the signal says don't record this, the device will respect that command. And the FCC's decision, so that was an order by the FCC, it was policy, it was then vacated on the grounds that the FCC actually lacked the legal authority to issue that decision. And in addition, Congressmen Coble and Berman were going to authorize war against peer-to-peer file sharing. There's this other anti-hacking statute out there. Copyright owners were afraid to engage in vigilante justice on the grounds that they might actually be criminally prosecuted as hackers. So this act would have given them a safe harbor from anti-hacking liability in order to engage in self-help in enforcing their intellectual property rights in the distributed network environment. So 5 years ago. Now we see the PIPA is just, and SOPA are a different version of that. It's still rage against the machine, but things have changed. Instead of downloading all the content, what are you younger folks doing? You're streaming. I don't want to manage a big library of content. It's all there. I can get it from a Russian site. I can get it from a Chinese site. You know, maybe I'll watch TV on Hulu. Maybe I'll watch it from the Mega Upload or whatever, mega.com. Just out of curiosity, how many of the folks, let's say under 30, watch television programming primarily on a television set? One. How many of you watch it primarily on a personal computer or an iPad or something like that? Yeah, okay. This has shifted. And that's because it's available. We got broadband now. Broadband is working, but broadband just makes the threat, it's a different threat now. Because if you remember, the international deal was we wanted that TRIPS agreement so that we get all the other countries to sign up to having the same kind of IP rights that we have. And then they had to have judicial proceedings that were effective so that Hollywood or the copyright owners could go to China, could go to Russia, bring a local action, and get these sites shut down locally. Doesn't happen. Yes, on the books, these, well, Russia wasn't a member of the WTO until recently, and China has on the books laws that would allow for the shutting down of these sites, but the judicial process is not effective for getting that done, and trying to get countries to change their judicial systems is a much bigger ask. And so what we get with SOPA and PIPA is we've got to get control over either the connections on the network to these sites, and that was the so-called break the internet provisions that would have changed routing of domain names or resolution of domain names, but also seek control over the financial flows. The legislative precedent here is the anti-internet gambling sites. In fact, the internet gambling for sort of college sports prohibits Visa and MasterCard from processing payments to sites that provide for that betting. So we have a kind of follow the money precedent in the law that Congress was looking to when those provisions were put into the bills. Alongside this, Bruce Lehman's move toward the international fora, toward using the executive branch as the site for intellectual property policy making has hardly gone away. It has become institutionalized in the Patent and Trademark Office as advisors, and now in the U.S. Trade Representative's Office, where there is an assistant U.S. Trade Representative directly responsible for intellectual property, to put into every free trade agreement an intellectual property chapter. And I put the words in quotes because free trade agreements traditionally were about quotas and tariffs and about how much of your goods will you take in exchange for how much of my goods. But the IP chapters in these agreements are international obligations about what the substance of your IP laws will be, or what the substance of the penalties, or the substance of the enforcement provisions. And so normally that kind of policy is made in other fora, but that policy is being made in free trade agreements. For example, if you look at the raft of the US Panama, US Korea, US Colombia free trade agreements, the US Trade Representative said that if we wanted to create a statutory license for Netflix or YouTube in order to allow web retransmission of television programming, we can't. Congress would violate our international obligations if it were to pass such a law. And so one question for the students who want to write about this is, does the US Trade Representative have the legal authority to enter into these kinds of agreements ex ante? Their line is that we are only coloring within the lines. All of our obligations in these agreements are fully consistent with US law, and their version of fully consistent means if there's an open policy question that Congress has yet to decide, and we choose to decide that, we are still coloring within the lines because we're not requiring that Congress change the law, even if we circumscribe their discretion in adopting such a policy. And just for the con law folks to be clear, of course, these treaty obligations are merely federal law. Congress, as a matter of US law, could change the law at any time. But as a matter of international law, these are international obligations. If Congress were to change the law domestically, we would be in violation of these treaty agreements that we've entered into. So the anti-counterfeiting trade agreement fails in part because the kids in Europe were jealous about the internet blackout here and how effective it was, and so 60,000 Poles took to the street in Poland on a very cold day to say, protect our internet, hands off our internet. And for other reasons, ACTA fails primarily in Europe, and once that's done, it's pretty much done. Now we've got the Trans-Pacific Partnership Agreement, which also has an IP chapter in it. I was able to meet, along with my colleague Peter Yazzie and Sean Flynn, we got to meet with the lead negotiator on this, on the IP chapter, along with folks from the Copyright Office, to talk about what their story was with regard to copyright on the internet. And I'm encouraged to report that rumors that we had heard from prior trade negotiations were that the trade representative was talking down fair use. Yeah, I know that we have fair use, but the argument was technically fair use might be in violation of the TRIPS agreement. We know that no one's going to really bring that case against the US, but the sort of backroom chatter was, you don't want to adopt fair use, that would be a risky thing to do. We have it, so we're probably okay, but you don't want to do that. And the current administration, the current folks have changed that tune. They never owned that publicly. But now they were willing to represent publicly that not only do they agree that fair use is fully consistent with our TRIPS obligations, but fair use as interpreted by the US Courts of Appeals, which includes some pretty healthy interpretations of fair use. And in their view, that is what US law is, and that US law is fully consistent with TRIPS. And they were willing to say that other members of the Trans-Pacific Partnership Agreement ought to take a serious look at introducing this kind of flexibility into their national copyright laws. This is a big change. This is a change in the way that the sort of rhetoric and the tone about limitations and exceptions in copyright at the international level are being conducted. Further evidence, the White Oak Treaty for the Visually Impaired and Print Disabled, which now looks like it will become a treaty. Its effect on the ground, I can't say I'm that confident it's going to do a lot to increase access for this community. But symbolically, rhetorically, this is an important moment where it would be the first international multilateral agreement for the purpose of cutting back on the scope of copyright, an international obligation to cut back on copyright. So here I want to offer then what I think is a shift in the dialogue and the way to think about this, that limitations and exceptions in copyright have now been shown to be enabling doctrines. They are not merely a taking back something from the copyright owner. It is public policy made for the purpose of enabling socially productive activities, like internet service providers creating platforms on which a lot of user innovation can take place, like allowing educational uses and other kinds of fair uses, like giving certain communities enhanced access. That's what limitations and exceptions are. They're not merely sort of parsimonious pulling back from the copyright owning community. So copyright revision is happening around the world at the national level. The multilateral level is not, there's not a lot of action. The Trans-Pacific Partnership Agreement is a plurilateral agreement. We've got this small deals like the visually impaired at WIPO, but no big framework deals. So instead, the action's at the national level. And we see that this enabling doctrine approach to limitations, approach to flexibility is on the rise. So Israel used to have the 1911 British Copyright Act as its Copyright Act. They've now adopted a new act. It explicitly adopts US fair use, in part because we have such a rich jurisprudence, and that is now the law in Israel. South Korea, in the wake of the US Free Trade Agreement with South Korea, adopted an open-ended provision in its law. It's a kind of funky creature. It takes the three-step test from the Berne and TRIPS, and then takes the 4 fair use factors from the US and bolts them together. So the judges are going to have fun with that. India went through a copyright revision, looked at but chose not to do a sort of fair use style. Pending the draft legislation in China and Brazil, both have an open-ended clause that would allow for flexibility. And the reason for this is the digital environment. All of these countries are realizing that innovation is the name of the game, and that they are being told by their innovation industries that the inflexibility in their national copyright law is one of the investment risks, one of the hindrances that is holding them back. Now, whether that's true or not, that's become part of the story, and we're seeing legislative responses that respond to that. In the US, where do we go? We've got a lot of issues that we might need to deal with. Certainly the orphan works mass digitization issue is probably one of those problems that can only be solved through legislation. But whether that will happen or not, it's too hard to predict, given that it's hard to predict whether we're going to get any legislation in this current environment. But I do think anyone who's overconfident by the SOPA PIPA defeat should not be in the sense that I fully expect that we'll see more enforcement legislation. That part, we're sort of at a cross current where more flexibility is advantageous, but more enforcement is still desired, and we're going to see legislation that reflects those two different views. And I would expect that the follow the money provisions of SOPA and PIPA may be reintroduced because those faced less opposition, at least from the internet community, although we're going to get more from the financial services industry. All right, so we're not done yet, but just take a minute. Are there any questions about the legislative sort of overview? We're going to talk about litigation and licensing in a minute, but I thought, go ahead.
So as a non-lawyer type, I've heard it said that fair use is a defense, not really much of anything else. With all of this stuff happening internationally with fair use, does that change at all, or is my understanding of that even
Formally, I still think there's room to argue that it's not, but as a practical matter, in litigation, it functions as a defense. The copyright owner just has to come into the court and say, I own a copyright, I have these exclusive rights under the law, you just did something that falls within my exclusive rights, you're an infringer. And then it becomes your job to say, maybe on the face of it, I'm an infringer, but actually it's a fair use, and therefore I don't owe you anything. But to say it's merely a defense, I think, undercuts its value. That is, when the copyright owner recognizes that you can say fair use in response, and if you have a credible reason for saying fair use, it makes the going after you in the first place a less attractive first move. And what we've seen, so that the knock on the flexibility is it's so uncertain. What do? I don't know what to do. So we see different ways in which that greater certainty and fair use is emerging. Through case law where you get precedents, and now you say, well, my case looks just like that case, and therefore, if that was a fair use there, it ought to be a fair use here. So reverse engineering of software in order to get at the uncopyrightable functionality of the software is pretty well regarded, well understood that the fact that you have to make a copy while doing the reverse engineering doesn't make you an infringer. That's a well-recognized fair use. Making fun of the copyright owner in a parody is a well-recognized fair use. And my colleague Peter Yazzi's engaged in what I think is pretty entrepreneurial acts of getting creative communities that use copyrighted works to get together to discuss what kinds of practices they engage in, which ought to be considered fair and not, and then issuing statements of best practices that deal with the common uses in their community to give you a more concrete understanding about what's fair use. So they got one for documentary filmmakers, for UGC and other kinds of works. So there will always be uncertainty at the edges, but I think we're in a stage where there was a time when fair use was considered almost off the table as a reasonable basis for moving forward, and that has changed. So just one concrete example, a partnership actually between the Stanford Fair Use Clinic here and at American University is insurers would not insure documentary filmmakers who relied on fair use for clips in their movies. And after these best practices were promulgated and negotiations took place, the insurer will now take that argument as an insurable risk. So that's a pretty nice concrete win for fair use.
On that point, it seems to me though that fair use doesn't really deter that much litigation in practice, especially when the fair use has some sort of commercial intent. Can you speak at all to fair use and commercial applications and what a transformative use is?
So the question for the web is, can you really say that fair use is something you can rely on, particularly in the case of a commercial use, and can I define a transformative use? So when we talk about the litigation, we'll talk about that a little bit more, but there was a time when it looked like the Supreme Court said there's a presumption against any commercial use. The Supreme Court pulled back on that, so the Supreme Court's been clear that you have to balance all of the factors. What's happened that's new, that's made fair use a more reliable doctrine, is that transformative has become a magic word in the courts, that if it's transformative, you have a high likelihood of succeeding, and transformative no longer just means parity, no longer just means adapting the work, it also means transforming the purpose for which the use is made. But if it's a commercial use, there's going to be the countervailing concern that the commercial use is the kind of use that ought to be paid for in a license. But we're going to get deeper into that in a minute. All right, so intermission's over, back to the slides. Let's talk a little bit about the litigation. Now, again, the decisions that have been made in the litigation over the last 20 years are certainly important in influencing outcomes on the internet. I just would submit that some of those outcomes were fairly predictable, and that the investments in buying the precedent made good business sense, but were not entirely surprising. But I will call out at least some of the cases that I think did set precedents that were influential in shaping the digital environment, shaping investment risk, channeling entrepreneurial activity. So I Crave TV was an early case involving a Canadian website where Canada had a limitation and exception and enabling doctrine in its law that permitted retransmission of television broadcasting under a statutory license. But that was within the territory of Canada. US subscribers quickly learned that they were asked for a phone number to get access to the streams, and if they put in a Canadian area code, voila, they would get access to the streams. The website was sued in Pennsylvania on the grounds that by sending those streams into the US, the site was violating US copyright law. And the US federal judge agreed with that proposition and held them liable in US law, and effectively was able to shut them down. So that, both the fact pattern of sort of distant streaming of television put the industry on notice that this was a risk that needed to be dealt with, and the holding about territoriality suggested that US copyright law could be used against distant alleged or actual infringers when the infringing activity took place in the US. And now we're sort of, what's old is new again, as we see a lot of litigation. We are in the midst of a fight about whether we're going to get TV on demand. Right? That is what, in my view, that's SOPA, PIPA, plus this litigation is all about whether we're going to get TV on demand. And that sort of flows into the licensing conversation. Where we are right now, you know the Who song Magic Bus? Right? So we're Roger Daltrey. Right? We're saying, I want it, I want it, I want it. And the industry's Pete Townsend. You can't have it, right? Because they're not going to make as much money in an on-demand world, they think, and they're not going to license their way into an on-demand world. But we're going to keep pushing as consumers because that's what we want. And this is the tug of war that will take place in legislative litigation and licensing fora as we sort of sort this out. Okay, well, of course the Napster case has to be mentioned. It did important things. It affirmed the Sony safe harbor for contributory infringement, while at the same time expanding the scope of vicarious liability that required a direct financial benefit from infringers over which you had control or supervision. Napster wasn't directly making any money other than investment capital, but that was sufficient for the court to hold that there was enough money happening because of the infringing activity to hold them vicariously liable. Also in the district court, we had the specter of investor liability, that this idea of going after the money has been part of the litigation and legislation strategy from the beginning. Similarly, then Grokster comes along, the Supreme Court, by effectively ducking the issue, the court's opinion affirms Sony by not changing it, and introduces inducement liability. Some might argue it was always there in COA in the contributory infringement. It certainly gave us a new litigation vocabulary to use more frequently. We've also got mp3.com. Now this was an important early case where the fair use was given a narrow reading. This is the technology where if you owned a CD and you wanted to listen to your music on some other device, if you registered the fact that you owned that CD, then it would get beamed to you from the mp3.com site. What was the problem? mp3.com itself made the copies. You didn't make the copies that it was streaming to you. And that becomes a distinction with a big difference from the court's perspective, as those copies that mp3.com made were held not to be fair uses. Now this is just a trial court opinion. In addition, then, the lawyers who gave the website an opinion that it was a fair use were then sued for malpractice liability because the copyright owners purchased the assets of the bankrupt estate in order to bring this claim, against the lawyers in order to chill any reliance on fair use. So there was a time when relying on fair use was supposed to be scary from the content industry's perspective. And again, the specter of investor liability was raised to keep chasing investors away from these new opportunities. But the world has changed, right? So in this UMG versus Shelter Capital case, in addition to the extensive interpretation of the safe harbors, we also get the investor liability theory raised again and rejected with an interpretation of secondary liability that leaves investors with a fairly broad room to operate and a fairly broad comfort zone in which they may operate. Cartoon Network is the case about now why the copyright owners brought this claim that surely they think this was not a good idea. I have reason to believe that at least some lawyers who represented those copyright owners did not agree that this was a good strategy. And the reason was that the question presented was whether a buffer copy of television programming held in memory for 1.2 seconds reproduces the copyrighted work in copies, where copies is a defined term that says that the work of authorship can be perceived, reproduced, or communicated for a period of more than transitory duration. We had case law from California that suggested that every time you load any copyrighted work into the RAM of your computer, you're making a copy, and the industry had come to take that to be true. But the Second Circuit reads statutes, and they read the full text of the statute and decided that the words transitory duration have to be given meaning, and chose to decide that in this context, 1.2 seconds was only a transitory duration, and therefore Cablevision is not making a copy. The reason I say they regret is every time you create space in copyright law and it's about copyright on the internet, somebody's going to figure a business that can be made to enter that space. And in the wake of Cartoon Network, we get Aereo, which is currently on appeal in the Second Circuit. We get Zediva out here in California. Well, if I can have a remote DVR service, how about a remote DVD player? Isn't it the same principle? Well, at least the trial judge here said no, it's not. But the theory embraced by this decision creates the space for that. Although I find the outcome in Viacom versus YouTube, which holds that YouTube is operating within the safe harbor except for some early infringements, to be unexceptional, it is an important precedent to just reaffirm the platform ability that 512C creates. The Perfect 10 case is, again, an over-aggressive, overreaching plaintiff that then creates precedents that other parts of the copyright owning industry would prefer were not on the books. Perfect 10 sues Google and Amazon for thumbnail images that they use in part of their image search. Two important claims are resolved in that case: whether it's a fair use to make a thumbnail for the purposes of making it the image used in search. That becomes a transformative use. It's the same image, the image hasn't been changed, but the purpose for which it was copied is transformative from the reason it was put on the web, and that is the single most important fact that made it legal, right, Andrew? And the display right does not cover links. There was a close call in a prior case in which the Ninth Circuit had held that an inline link exercised the copyright owner's right of display, which is to show a copy. So the link doesn't, the argument was the person who posts the link on their site is doing the showing, even though from a technical perspective, the link has the user's computer go make a request, and the showing is done by the server on which the file sits. But in that case, it looked as if the file was being served up by the search engine. And if that's how it looks, the argument was that's how the law ought to treat it. Ninth Circuit panel issues that opinion. The internet community freaks out because now links need a license. The court gets inundated with amicus briefs. Here, we're just your friend. We're friends of the court. We're just your friend. Not a good idea. The panel says, okay, we didn't really take briefing on all of that. Let's just withdraw that opinion. And here's a new one, and that's gone. Right? So then the Perfect 10 opinion comes along and says, we get it, we get it. Links don't need a license. And says that the display is made by the person in control of the server that sends the file, not the person who puts the link on their site. Perfect 10 also goes after Visa, they follow the money. And in its split opinion, the Ninth Circuit says that even after Visa gets notice that it's processing payments to an infringing site or a site that has infringing material on it, that Visa is not contributorily liable for that and not vicariously liable. We may see that Perfect 10 was not the best plaintiff to be bringing some of these claims, but I would say that theory is not fully resolved, especially given the strong dissent by Judge Kaczynski. And so that's a theory that's out there for ripe for further revisiting. Transformative use. So this is the other note topic for folks. So Georgia State University is sued by two academic presses funded by the Copyright Clearance Center in half, the licensing agent for most of the publishers. The theory is that electronic reserves are nothing like reserves, where a physical copy was sat behind a circulation desk and one by one students had to check it out. An electronic reserve, the plaintiffs claim, is merely a course pack that's been made without a license, and it's therefore not a fair use. You're circumventing a well-established licensing market, and not for transformative purposes. You're making educational materials available for educational use, and therefore you're an infringer. The trial judge holds that most of the chapters of books posted by professors are fair use, but largely on the grounds the licensing market is not as robust and well developed as the plaintiffs alleged. Therefore, a potentially Pyrrhic victory, because if the copyright owners get better about establishing the robustness of the licensing market on the reasoning of the district court, all of those educational materials you get through Blackboard or MyLaw or whatever you're using would require a license. So my question to you and to the copyright community is there a limiting principle? Because digital technology makes the ability to create the licensing market increasingly cheap. If all you have to do is say, I am now here and prepared to accept payment for any use that fits the following definition. So I don't have to do anything to engage in a transaction with you other than accept payment by Visa, PayPal, or bill me later. And if that's all it takes to create a licensing market, and under the fair use analysis, avoiding an existing plausible licensing market weighs against the fair use, is there a limiting principle on that argument, that even when you set up the licensing market, we should ignore it because fair use has some grounding in the law other than just sort of solving transaction costs problems? Well, maybe there's some hint that in some of the case law that you can't create a licensing market for transformative uses. That if I write a book and then issue a parody license, anyone is free to make fun of my book on any terms. I have a sense of humor. You can do whatever you want, but you got to pay a license. Should it still be a fair use to make fun of the work without paying the license when it's so easy to do? Well, you have to articulate a limiting principle on that fourth factor in order for that to be a successful fair use defense. So at least one court has suggested that markets for transformative uses, or licensing markets for transformative uses, are the kind we can ignore. But that's one case, and there are other cases that pull in a different direction. So this is an issue that needs deeper thought, more work. Molly, sitting in the back, Molly Van Houweling, has written an interesting article that suggests that even when there's a price for the work, maybe fair use is a way to give access to the poor, because if the price effectively denies the access, then the licensing market should not be given the weight that it normally is. And fair use is a sensitive enough balancing act that we might be able to do that. All right, we're done almost. Licensing, this is where the action is, I think, and here's why. All the hagiography around Steve Jobs can be a bit much sometimes, but he was clearly an interesting personality, and among his business successes, I think the iTunes deal has to be acknowledged, that he was working with a content industry that still wanted to secure the beachhead, still wanted a secure space, and he said, I've got it, come on in. I have built the secure space for you. And he got licensing to the music, which fundamentally starts to break apart the CD model. We're now getting music a la carte. For better or worse, it's a major change in the digital environment. That one licensing deal opens up the space because you had these nervous content owners that needed a secure space to put their precious content into, and he built it for them. And if you follow then, a series of other licensing deals have been made where we're getting access to more content on the web. We still don't have the full range of content by any means. We still are sitting there like Roger Daltrey saying, I want it, I want it, I want it, and still being told like, we can't have it. But there's a lot more content on online now than there was before. In addition, there are other pressures in play. So under Section 512, YouTube has won its case. It doesn't have to do anything other than respond to takedown notices, but that's not what it's doing. Google is watching everything on the internet, analyzing everything, and then offering licensing deals, because Google needs to make money too. And so Google's interested in doing deals and interested in building up the licensing market, even though it sits inside the safe harbor of Section 512. As we talked about this morning, user-generated content in the aggregate has a lot of value. Why is somebody going to give Pinterest $2.5 billion? There's a lot of content on there. Now, admittedly, a lot of that content is taken by professional photographers, and they have a reason to be concerned about $2.5 billion being invested in a company whose success is in part due to their images. I think the real value in that site is the conversation that's going on through those images rather than the creativity of the photographers. But their creativity is certainly part of what makes that conversation. So are we going to resolve that through litigation or licensing? My prediction is licensing. Right. Now, as a member of the board of directors of Creative Commons, I can't not say anything about public licenses. In terms of its shaping of the internet, Leela, I appreciate all the props. I think, if you take public licensing as a whole, this includes all the free and open source software licenses that clearly have had an important effect on the environment. It is definitely a big piece of the universe. Good news on the open access front. So the Obama administration at 11:30 just announced that a new policy in which it would require the remainder of federally funded research be put up on the internet for free, and research data should be put up on the internet for free to the extent possible. So this is a policy that's been 4 years in the making. So I'm having a good day. I think in addition to sort of, one interest to the Pinterest users who are worried is, hey, here's 200 million photos. If you want to, some of them have to be part of the, able to be useful for part of the conversation. But I want to alert people who are either entrepreneurs or lawyers interested in the public licenses. The big business opportunity is in open educational resources, because there's a real business case for openly licensed materials to take a much bigger share of the educational publishing market. The reason is the open license can allow for the materials to be updated, and you still need to pay the authors, but we're seeing pots of money being put aside to pay the authors, but pay them once. Rather than do a running royalty, pay the author once to create the electronic textbook, put it out under an open license, and let it be updated by teachers, users, adapted, etc. Saves money and higher quality content. This is not hypothetical. U.S. Department of Labor, U.S. Department of Education have put $2 billion into creating community college level courses for job retraining. All of the grantees who accept that money and create this course material have to put the material out under a Creative Commons attribution license. That's a $2 billion investment in open licensing. State of Utah is putting pots of money into the creation of K through 12 textbooks that will be available under a Creative Commons attribution license. So that means the next time the state of Ohio decides that it's time to go get a sixth grade math textbook, should they pay Pearson a couple of $1 million, or should they take the book that Utah developed? Utah is now effectively publishing educational content that can compete with a price of zero or the price of print on demand with content that's being sold by the commercial publishing industry. If you imagine you're a state legislator, you've got a tight budget and you're trying to figure out how to save money, you can get a better textbook for a cheaper price. Pretty attractive. So that's why I think there's a real business case for building out this. And OpenStax College, there are a series of people starting to play in this space, but it's just a beginning. How this business case intersects with the MOOCs is still very much up in the air, under conversation, but another place where that's going to be a kind of a licensing conversation, and that's going to be a place where creative lawyers, creative business people could do something really interesting for the future of education over the internet. So I'm very hopeful. I'm going to be putting some of my energies into trying to figure this out, because I just think this is a huge upside for society, and we still pay authors. That's what I like, is we're still consistent with what copyright's about, which is rewarding creative people for their creative contributions, but we can do it better, smarter, faster, cheaper, because the internet lets us. Last point. Section 114 is a different version of creating space in copyright law. It creates a statutory license for the public performance of music, sound recordings. Pandora builds its business on that statutory license, right? Anytime, surely you've had you go to Pandora, you ask for a song, it says, I can't give you that song. Why can't it give you that song? You go outside the United States, you try to get Pandora, they say, sorry, for licensing problems, we can't send you this stream. Why? Because it's a US-based statutory license. We created a space, they created a business to show that internet radio can work, and now we're getting voluntarily licensed services coming along because Pandora showed that it could be done. They built the market first, and now we're getting the voluntary licensing following it up. So Slacker says they've got more music than Pandora. I'm trying to figure out how that works, because under the statutory license, Pandora has anything that's been released in the United States. So the only way Slacker could have more music is if they've got licenses to content that's never been released in the US. I think what they mean is Pandora's algorithms give you this very restrictive playlist, but that's the algorithm, not the law. And it's not, they're saying we're better copyright lawyers than Pandora. I'm not buying that. They might have just a different business model. But this is encouraging, right? We're now getting access to content that we never would have. Now, musicians say they're not getting paid enough. I think they're probably right. Certainly, you hear about oh, great, I got a 36-cent royalty check. Yay me. But we're in a transition here. We haven't figured out what the price is yet. That's another piece of how this is going to work. Who's going to make the money? Should it be Verizon and Comcast? Should they have to share some of their rents with the content industries? This is all up for negotiation. But I think it should be negotiated rather than litigated or legislated. And I think that's what's happening. And so if you're trying to shape the internet in the next 10 years, this is where I would suggest the action is. So in conclusion, I think, yes, we want to secure the beachhead to some extent. Nothing is risk-free, but authors should be able to go online, and if their purpose is to make money, there should be places on the internet where you can go online with your content with a reasonable prospect of getting rewarded. but the internet also has to create a safe space for innovation, a safe space for users to be able to express what they want and to be listened to and to be heard. And through this dynamic tension, over the next 10 years, 15 years, we will see what we can come up with. But I am on the whole hopeful, and also on the whole out of time. I appreciate your patience, and I look forward to this afternoon's panel. So thanks. So what do we do? You want to state a time, or do you want to allow for questions?
Why don't we, maybe since we're running a little bit behind, we'll just run a little bit more behind. And what we'll do is perhaps 10 minutes for questions, which will take us to a quarter to, and then we'll allow for another 5-minute to 10-minute break, and then we'll pick up just a little bit before 2 o'clock for the next panel. If you have a question, please approach the microphones. Feel free to step out. Otherwise, if there are no questions, we'll just we'll take a break.
Oh, 2 questions. First, John Barlow said in that either that article or an article in Wired around that time that everyone is complaining and trying to figure out how to put the genie back in the bottle. Remember that?
Right.
Back then. And he said, the point is they don't get it. There is no bottle. Do you think it was prophetic or incorrect?
Again, to the extent, if the claim is copyright just is over and done with, and we're just in the sort of dying stages of it, I think that's not right. I do think there's enough of a container in the digital environment for digital content to be contained such that people will pay for it. You know, 1 billion sales on iTunes is one piece of data I would point to suggest that music's all available through other services.
I think actually iTunes undermines and proves the contrary to your point, because iTunes went away from DRM, realizing you can't protect Ether. And what they did was employ that model that was used by the defendants in Napster in the argument of, and not in Napster, but people defended it. Look, if you just make it cheap enough and give a good enough quality, people are not going to want to bother with anti. So I think the barrier really was just making it easier for people and making it cheap enough. Why would they want to bother with some crazy peer-to-peer network at 3 in the morning?
So yeah, then I think the question is, if we strip away copyright, does anything change? Well, the one thing that might change is if we strip away copyright, then someone else builds an iTunes to compete down the price, right? And so I think copyright is at least layering on a little bit of a premium in the iTunes model, but I don't think you need DRM to do anything further.
And then the second question was, you were positing litigation as it seemed to me mutually exclusive to licensing. Don't you think that litigation is simply diplomacy by other means? They all end up in litigated settlements anyway, and when I do deals, you do it with reference to what the litigation outcome might be if we don't work out our own pre-settlement. You can consider these things.
No question. The three are always mediating each other. I think the point is sort of where, if you're a creative young lawyer trying to figure out where to focus their energies, am I going to shape the future of the internet by bringing test cases or by negotiating the big licensing deal? I'm just suggesting we're in a phase where the latter is more.
Mama, don't let your kid grow up to be a litigator.
And then here comes the litigator.
First of all, thanks a lot. This was an amazing survey of the landscape. The previous comment was sort of like waving a red flag in front of me. I have to make one comment. Litigation is a way of negotiating licenses, except that you're not starting from the standpoint of what a reasonable royalty range would be. You're starting from the standpoint of $4.5 billion in statutory damages in many cases, which sort of distorts the negotiation. Right. Now, you mentioned SOPA is sort of dead, but we may see new SOPA-type things. You also mentioned that Perfect 10 versus Visa may not be the last word because of Judge Kaczynski's very, very forceful dissent in that. I wonder if both are becoming irrelevant, and I'm wondering what you're seeing, because what I think I'm seeing is what I call soft SOPA in effect now, operating out of the office of Victoria Espinel in the White House. where it appears that she's calling people in and saying, here's how you're going to do things. And I've had 3 clients be told by payment processors, we're going to stop processing your payments. Exactly what SOPA was seeking. It's happening, at least as I'm seeing. I'm wondering what you've heard and what you're seeing on that front across the range of things that SOPA and PIPA were trying to accomplish.
Yeah, so it's a good point. In administrative law, we call that regulation by jawboning, right? If you can't go through a formal process to get a rule enacted, officials in Washington can jawbone the regulated community into doing what they want under the threat of some formal rule that they might like even less. And I think that's definitely part of the story is, here's an easy way for us to ease up on supporting a renewed legislative push. If we actually see some cooperation, then maybe we, as you say, start a soft rule. So that doesn't, I haven't had that conversation, but that doesn't surprise me at all. And in part it's because both in litigation and legislation there are real threats to be made by these officials about what public policy might become and why playing ball with this agenda would make sense from a business perspective, even though you're losing some income.
Well, thank you for your work with Creative Commons. Obviously a great way to get by some of the transaction costs in various deals and with people who want to make their work available for use and those that want to use it. I'm wondering your response, your feedback and thoughts to the recent change to have only attribution with attribution licenses and to get rid of the non-attribution in your new licenses on Creative Commons. Obviously that again makes it so that it's not useful for a whole set of creative uses where it's not appropriate to put in various attributions, and I understand that a lot of the content creators want that, but there are many who don't care and they just want their work to be used.
Okay, so the current version of the license is when we made the switch to requiring attribution without asking. But it's attribution as the copyright owner designates. So if the copyright owner wants to say no attribution, you can opt into a no attribution license. But the default has been flipped because 98% of licensors were choosing the attribution condition. So at that point, you got to listen to the people. But is there a particular use case where one other point is the attribution requirement says reasonable under the circumstances. So what are the circumstances in which giving attribution is problematic?
So certain creative uses of the work where you don't want to include text or whatever username, could be some strange name. It's not really a normal editorial use where you have the photographer or an actual name included, and can take away from some presentations or the like to have that there.
Yeah, although you can roll credits at the end. I mean, there are lots of ways to implement the attribution requirement that doesn't undermine the aesthetic goals. And maybe offline, if there's a specific use case,
sure,
we can talk about that. But yeah, I mean, I take the point, but I think on the whole, people really do care about getting credit, and so that's why the licenses reflect that.
Thank you.
All right.
My question is about compilation copyrights, specifically for automated databases. And what I've noticed, I'm not an attorney, but as an entrepreneur, that a lot of websites, like Craigslist, for example, where they're the source of user-generated content from many different authors, they may or may not file a compilation copyright and then they won't license the content, they'll refuse to, but they'll use that compilation copyright to make sure that no one else can compete using the same information. And I think it has a pretty, has a chilling effect on innovation and things that can be done with that information. And I understand that compilations, copyrights apply to the selection, arrangement, coordination of the elements within the compilation, but I've seen in practice some courts say that the elements are actually protected by virtue of being in that compilation in and of themselves. I can, cite some cases for you. But my point is that, is that indeed the case, or is that an error? And when does copyright misuse come into place? Is it simply, it is an affirmative defense, but is there a cause of action, or is there a trend for copyright misuse to become a cause of action?
Okay, lots of questions there. So just so everyone's clear, because there are some non-lawyers in the audience, copyright attaches to works of authorship. In the case of a database, you have to find the authorship. What are the creative choices that somebody made in order to earn the copyright? In the database context, if the factual data are facts, there's no authorship there, but the selection and arrangement of those facts might be the creative choices that give you a copyright, but only in the expression that expresses those creative choices. So does Craigslist, and this sounds like this is a non-hypothetical question, but does a website like Craigslist engage in authorship in the way that it presents its listings? If it doesn't, then there's no copyright. If the selection and arrangement is because first in, first out, or something like that. It doesn't mean they might not assert a copyright claim. Lots of people overreach with respect to their claims to copyright. I have no basis for knowing what Craigslist's approach is on this. But, and some judges do get confused about the layers of authorship. So they think if there's a layer at the selection and arrangement layer, that therefore there must be rights in the constituent elements. And that could just be error. It depends on what those elements are. If they're photographs, right, then there is a copyright in the elements. If it's factual data, and a Craigslist listing is on the border of authorship, right? You have a selection of ways to say in your words that I am selling my 1999 Honda Civic. That seems to be a statement of fact, but if you start to describe the car in colorful language, you're now making authorial choices that give you a copyright. So, it's case specific.
But just to the question though, is including that text, that descriptive text, say it does qualify for copyright by itself, or those photos in the compilation, does that automatically give that protection by itself, that text? Well, or would you need to file those photos as a separate registration?
Well, so let's be clear. You don't have to file to get a copyright. You get a copyright automatically. In fact, you get almost 200 copyrights automatically. Anybody who's taking notes in the audience? Do you feel it? The law is showering down upon you exclusive rights. And by operation of the TRIPS agreement and our other international agreements, you not only get protection in the United States, but in almost 200 other countries, all at once, at the moment of creation. So there's those. Now, to sue on those, you have to register in order to bring the lawsuit. But the copyright exists at the moment it's created. So you knew that, or was that?
Yes, I did. I guess I was referring to the registrations and the ability to enforce them.
In order to be able to enforce. Well, yeah, the problem, there's a theoretical problem, which is what is the work of authorship? It's undefined in the Copyright Act. And you can be a little flexible about which work you're asserting. So what I'm hearing you ask is actually a more technical question, which is, if the registered work is the compilation, does that registration then give you the basis for asserting jurisdiction in the federal court for infringement of a constituent element of the compilation?
Correct, and I know something about it, but I don't know the answer, of course, I'm asking.
Yeah.
But I mean, I understand that whether it's one author or many authors, in this case there's typically many authors of user-generated content, it's not Craigslist. So in the case where you have many authors, typically they don't list the authors for each work. So if they did extend to the underlying elements, then in fact the entire copyright system, I think, would be deprecated, because how would you ever know what is actually copyrighted and who the author is?
Okay, point taken. And that is the issue about compilation copyright has been litigated in terms, and the Copyright Office has some discretion about what it'll register. All right, it sounds like people need a break, and I appreciate your patience and time, and look forward to the afternoon.